No, okay, wait. I'm live. I'm live. Hey, viewers. Hey, everybody. Yes, we are live again. Again. I have some problems for some reason. YouTube today, I can't myself in the video thing, though other people can apparently see me. So the microphone's in front of my face, where I look goofy and I don't know it. Too bad. All right. The Erie Doctrine. Here we go. Big time Civ Pro case. Erie Railroad versus Tompkins, U.S. Supreme Court case, 1938. Justice Brandeis of the Brandeis fame gives the opinion of the court. The question for decision is whether the challenged doctrine of Swift v. Tyson shall now be disapproved. Tompkins is a citizen of Pennsylvania, was injured on a dark night by a passing freight train of the Erie Railroad Company while walking along its right-of-way at Hughestown in that state. He claimed that the accident occurred through the negligence in the operation or maintenance of the train, that he was rightfully on the premises as licensed because he was on a commonly used beaten footpath which ran for a short distance alongside the tracks, and that he was struck by something which looked like a door projecting from the train alongside the tracks by one of the moving cars. To enforce that claim, he brought an action in the federal court of the Southern District of New York, we would now say, which has jurisdiction because the company is a corporation of the state of New York. It denied liability and the case was tried by a jury. The Erie insisted that its duty to Tompkins was no greater than that owed to a trespasser. It contended, among other things, that its duty to Tompkins and hence its liability should be determined in accordance with the Pennsylvania law, and under the law of Pennsylvania, as declared by its highest court, persons who use paths along railways right of way, that is, a longitudinal pathway as distinguished from a crossing, are to be deemed trespassers, and that the railroad is not liable for injuries to undiscovered trespassers resulting from its negligence, unless it is wanton or willful. Tompkins denied that any such rule had been established by the decisions of the Pennsylvania courts, and contended that, since there was no statute of the state on the subject, the railroad's duty and liability is to be determined in federal courts as a matter of general law. The trial judge refused to rule that the applicable law precluded recovery. The jury brought in a verdict for $30,000, and the judgment entered thereon was affirmed by the Circuit Court of Appeals, which held that it was unnecessary to consider whether the law of Pennsylvania was as contended, because the question was not one of local but of general law, and that, quote, upon questions of general law, the federal courts are free, in the absence of a local statute, to exercise their independent judgment as to what the law is, and it is well settled the question of the responsibility of a railroad for injuries caused by one of its servants is one of general law. Where the public has made open and notorious use of a railroad right-of-way for a long period of time, and without objection, the company owes to persons on such a permissive pathway a duty of care in the operation of its trains. It is likewise generally recognized that a jury may find that negligence exists towards a pedestrian using a permissive path on the railroad right-of-way if he is hit by some object which protrudes from the side of a train. The Erie had contended that the application of the Pennsylvania rule was required, among other things, by Section 34 of the Federal Judiciary Act as of September 1798, which is 28 U.S.C. 725, which provides, quote, the laws of the several states, except for the Constitution, treaties, or statutes of the United States otherwise require or provide, shall be regarded as rules of decision in trials at common law in the courts of the United States in cases where they do apply. End quote. Because the importance of the question of whether federal court was free to disregard the alleged rule of the Pennsylvania common law, we granted certiorari. which is the Supreme Court's right to review a case from a lower court. First, Swift v. Tyson held that federal courts exercising jurisdiction on the ground of diversity of citizenship need not, in matters of general jurisprudence, apply the unwritten law of the state as declared by its highest court, that they are free to exercise an independent judgment as to what the common law of the state is or should be, and that, as there stated by Mr. Justice Story, quote, the true interpretation of the 34th section limited its application to the state laws strictly local, and that is to say, apply the statutes of the state and the construction thereof adopted by local tribunals and the rights and titles of things having permanent locality, such as the rights and titles to real estate, to all matters immutable or territorial in the nature and character. It has never been supposed by us that a section did apply or was intended to apply to questions of a more general nature, not at all dependent upon local statutes or local uses of a fixed or permanent operation, as for example,